Hello, and today we'll be having a look at the criminal offence of burglary, which can be found in Section 9 of the Theft Act 1968. As with my other videos, the following whiteboard behind me, a clearer picture of what is written on it, can be found on my website where these YouTube video tutorials will also be posted. So let's begin. Well, there's two types of burglary. You have one which is found under Section 9(1)(a), another one found under Section 9(1)(b). And the essential idea behind burglary is that you have a person who is entering into a building as a trespasser and either intends to commit an ulterior crime, most commonly theft, or actually commits it even though they didn't have the intent in the first place. So that's the essential idea. Now, how they are differentiated is Section 9(1)(a), as we'll see, is to do with just merely going in with the intention that I'm going to cause grievous bodily harm to X, or I'm going to go in as a trespasser to commit a theft. Or Section 9(1)(b), where the person has the entry into a building as a trespasser, but may not intend to do this ulterior crime, but ends up anyway killing somebody or causing grievous bodily harm or stealing a jewel or something along those lines. So that's the idea of having these two types of burglary, to cover a wide range of situations, because in life burglary takes many different shapes. So let's begin with the actus reus. Now, there are three actus reus components and an additional one that is required for Section 9(1)(b), but we'll talk about the additional one in a moment. So let's begin with the first thing, that there must be entry. So the person being convicted, they must have entered into these premises. How do we understand this? Well, R. and Collins, 1973, made it pretty clear that entry has to be effective and substantial. So it cannot just be somebody putting somebody just standing by the window which is shut. It has to be entry into, actually that could be effective. I can't think of a situation where it wouldn't be, but it has to be effective. And then in Brown, 1985, where these two people, they broke into Argos and they only had their arms in, or there's some facts like that, but they still managed to steal goods. But they appealed because they said the entry wasn't substantial. And then the courts dismissed this because they said actually all the entry needs to be is effective. Following that, in R. and Ryan, 1996, here the person again, they were stuck in the window. The fire brigade had to come to rescue them out. I don't think they actually stole any goods, but the entry was still deemed to be effective. And what do we mean by effective then? Then is it that you actually have the potential to steal anything, or is it any type of entry? And what the courts basically were saying, that in previous cases, what we're trying to make clear is the whole body does not need to be inside a building for an entry to be effective. And as R. and Ryan 1996 established, this will be a question of common sense, which is left to the jury to decide. The second component of the actus reus of burglary is building. This entry must be to a building or a part of building. Now, building is not expressly defined and it's left to the ordinary meaning of words. However, I believe subsection 3 does basically make clear that inhabited vehicles and vessels are included in the idea of building, which might not come to your mind at first instance. Then we have two cases, B&S Leathley 1979 and Norfolk and Seekings and Gould 1986. Essentially, in the first case, B&S, what happened? There was a freezer container in a farmyard, and it was there for 2 years. And the court held that this was a building, even though it was just a freezer container. It was considerable size. It was there for a considerable length of time. This was a building. In Norfolk, however, there was 2 lorries that were being used for temporary space while a supermarket was being redesigned. They had electric power, cables, etc., but they were held not to be buildings. What do we take from these contrasting case studies? Well, it's the idea of permanence. So when we're looking at a building, we need a construction which has a degree of permanence. The last thing to mention in the actus reus of building is it can also be a part of a building. So people people are usually given free access to enter into a shop, but not all parts of the shop are open to the public. So behind the till, for instance, and this is exactly what happened in Walkington in 1979, that it was established that behind the till, this area was not permitted, and so entering into that would be trespass, and that would be counted as a separate part of the building. But again, this is something that they like to leave for the jury to decide. The third part of the actus reus is being a trespasser. So this concept of trespasser comes from tort law, and is essentially the idea of interfering with someone's possession or property, and they don't have authority for this interference, so they need permission in order to go into a particular property or have this permission. And this case of trespassing is made clear in the cases of R and Collins 1973, where the issue was this burglar a trespasser or not, because essentially the victim did invite him in. Albeit she had a mistaken idea that he was her boyfriend, she did invite him in. And similarly in R and Jones and Smith 1976, these two guys that go into the father's house, to rob the father's house. And basically what the courts are saying, that there was an excess of permission. They were allowed into the house, the father had given them, but did not give them permission to enter all parts of the house. They were a trespasser in some parts of the house. They lacked the authority. So those are the three components of actus reus. However, where section 9(1)(b) type of burglary is concerned, this is the type of burglary where you go in as a trespasser, you make entry, but then you commit this ulterior crime of theft or GBH. And so you have the additional actus reus that is required for the commission of the ulterior crime. So if it's theft, it will be I forgot the word, when you acquire. Anyway, I have a video on theft, you can have a look. So it will be the actus reus of theft or GBH or any of those crimes. Now moving on to mens rea. So the mens rea that's required for burglary, for both types of burglary, is that there must be an intention or recklessness as to being a trespasser. And here I think it's really useful to read out a quote from Collins, which I think explains it. What the quote says from Collins is, unless the person entering does so, knowing that he is a trespasser, and nevertheless deliberately enters, or at the very least is reckless whether or not he is entering the premises of another without the other party's consent. So it's the idea that you might not know like legally the situation that you're a trespasser, but you are trespassing in the sense that you are entering somewhere without any permission, that you're not allowed to be there. Now, some people say that this idea was expanded in Smith and Jones. This is about the two people who go to steal the father's TV, because there they basically say that the reason why the two culprits were trespassers, the reason why they were trespassers is because they had the intention to commit the crime, not because of them not having express permission. And this is all the time covered up with the fact that there were excess permission given. But this doesn't seem right with Collins, because Collins centrally asked the question, did they have permission to be there? Because otherwise the guy who was standing outside the window in Collins, he had the intention to rape the victim, and therefore he should automatically be a trespasser. Can you see there's a difference between Smith and Jones' understanding and Collins? Smith and Jones is saying that actually if you have the intention to commit this crime, regardless, then you are a trespasser, whereas Collins is saying, do you have permission to be there? Now, I don't think Smith and Jones will be applied as widely, and actually doesn't sit well with subsequent cases like Walkington, where the judgments go on and on about like talking about behind the shop, did they have permission to be there or not? Because if Smith and Jones was correct, then in Walkington, for instance, you wouldn't be questioning did they have permission to be there. You'd be just saying, well, they had the intent to commit a theft, so they're trespassers. But I think the central issue is that you understand that there is some flexibility as to the intentional recklessness of being a trespasser. Now, that's the first type of mens rea. Then there is an additional mens rea which applies separately to Section 91A burglary and Section 91B burglary. So starting with Section 91A burglary, after you've established that the person was intentional or reckless as to being a trespasser, then you need to establish that they had the intention to commit the ulterior crime that was present. And this is usually fairly straightforward, because it might be that there was a burglar's aim or purpose to take and acquire a particular jewel he knew was in this building. But there is an issue of conditional intent here, i.e. intention so long as they find something useful inside. But this was no bar to the conviction of burglary, and this was established in the Attorney General's reference number 1 and 2 of 1979. So basically, as long as there is some intent to go in and take something, even if it's not a specific item, a conviction of burglary can be found. You just need intent of this ulterior crime. Whereas in Section 91B, you don't need the intention of this ulterior crime. You need whatever the mens rea is required for the alternative crime. So for the mens rea of theft, you will require dishonesty and an intention to permanently deprive. So long as you have that, then you don't need anything else to prove it, because what essentially Section 91B is doing is saying, well, have you made an entry as a trespasser into a building or part of a building with the intention of being a trespasser? Yeah, you have all that, but then in addition, you met all the requirements of the crime of theft of GBH, so your Section 91B. Whereas if you've got entry into a building or part of a building as a trespasser with the intention to be a trespasser, but there is no actual crime committed, but you did go in with the mindset and the aim, I'm going to go in to steal those pair of earrings, then you will be found under Section 91A. So you can see the whole idea of having two different offences of burglary is to cover a wide range of situations. Sorry, this is a long video. Thank you for watching.